Good morning.
Good morning, Judge.
Morning.
Good morning.
All right, well, welcome to another Zoom oral argument session of the 5th DCA. I'm Judge Sasso, and I have with me on the panel today Judge Wozniak and Senior Judge Jacobus, who has agreed to sit with us for today. We have one case remaining on our docket. It is case number 20-1765 Ellis versus Ellis. As a reminder, we are being broadcast live on YouTube and it will be recorded. And we have 20 minutes set for each side. Mr. Grassley, I'll reserve 5 minutes for your rebuttal unless you say otherwise. And you may go ahead.
That's an aspirational goal, Judge.
All right. For that, you may proceed when you're ready.
Thank you, Your Honor. I'm Bill Grassley from Jacksonville on behalf of the appellant Elizabeth Ellis. Excuse me, for some reason I'm having nice throat issues this morning. I think it's a allergy time for certain plants, at least in my end of the world. The answer brief, the appellee admits that the failure of the trial court to enter an income deduction order and an allocation of the children's non-covered medical expenses was improper and requires remand. Which I appreciate, but that's just the beginning of a very long list of erroneous rulings contained in the final judgment that have financially devastated my client, which is the gravamen of this appeal. The first issue we raised is sort of a distinct issue, which is the failure to allow a quadro to be entered on the state pension plan. I'd like to just rest on what the briefs have to say on that issue. I want to make sure I mention it because the real meat of the problems here have to do with the trial court's miscalculation of both parties' income for purposes of child support and the equitable distribution and a resulting failure to award durational alimony to my client. There's also a separate issue about the income tax deduction, which hopefully I'll get before my time runs out. I'll get to raise that because that's fairly straightforward. It is not moot as requested or as claimed by the appellee in separate filings. The motion for rehearing that my client filed, which appears at the record at 977, contains both the proposed final judgments and the IRS regs that govern a whole number of the issues here and cover in very, very specific details all of the calculations. And I encourage the court, because memorizing 200 different numbers is not my strong suit ever, and I've been doing this for a long time. The reality is that the former husband was allowed to leave the marital home in May of 2019, paid no support, no mortgage payments, nothing until started paying $300 a month at the very, like in September, and didn't help any support for my client for until 2020, January.
Well, wasn't the evidence that the husband was depositing money into, I believe, the joint account, and his testimony was that that was supposed to be used for the mortgage payments each month?
Thank you, Judge. That's dangerously partially correct and substantively not correct. During the evidence was that during the marriage, this was a two-income family. They had a joint account. Both parties put their paychecks into the account, and the husband paid the bills. He left the marital home in May 2019 and decided that because he didn't live there anymore, that this was all going to be my client's problem. He paid no mortgage payments whatsoever until ordered to do so in January 2020 by the trial court judge, paid half of the mortgage payments for 2 months, and then filed a motion to defer the mortgage payments. He paid no child support for May 2019 until September, when he started paying $300 a month, which was at least $500 less than he should have been paying. So the truth is, the accurate state of the record shows unequivocally that no payments went into the joint account after he left the home. My client had to bear the financial brunt of not only paying for the mortgage for most of 2019, but for paying for virtually all of the children's expenses. And while, I'm sorry, Judge Jacobus, were you going to ask something?
No, you're good.
I'm sorry. So the reality is that the miscalculation of income is the basis for several errors here. The former husband's 2017, 18, 19 tax returns were introduced into evidence along with the W-2s and the 1099s because he always had extra work. He was worked for the fire department as a paramedic or emergency rescue person, and he always had a second job. The pay stubs for 2020 were introduced into evidence, which showed that he was on track for W-2 income only to make $75,000 a year.
But that was for 2020, and I think there was testimony that was out of the ordinary because of the pandemic, and he was working extra hours.
He always worked extra hours, and what was the actual testimony was from him. Now let's make sure we put this in context. We've had 3 different financial affidavits from the former husband, including the one at the last minute that claimed that he was not going to be making as much as he had already in 2020. Well, everything that happened after this trial in terms of his income is speculative. It is not part of this record. What the actual trial testimony and evidence showed, which he admitted that he was on track to make $75,000 in 2020. Well, the final judgment uses a figure of $5,038 or $68 for his income, which has no evidentiary basis whatsoever. You can't average or manipulate the figures in any way to find that figure. The trial judge also used an erroneous figure for my client when her actual monthly income was $4,006. The child support calculations under the final judgment used $4,538, and there was no evidence to support that. So the gravamen of our initial issue here is that there was no evidentiary basis for the figures used for the child support calculations on both the husband's side and the wife's side. And before I leave that, the final judgment as to the husband is even more egregious than what I've just said, because his testimony was, well, I don't think I'm going to be making any more overtime money. Not overtime, second job income in the future. Well, that's in the future. He was still making it as of the time of trial. And then the important part is his rationale for that. His explanation was because of the time sharing. Well, there's 2 fallacies in that, which is number one, he was not exercising time sharing. The parenting plan, which was entered by consent and which is found at 449 of the record, calls for him to have to undergo counseling and work into a schedule of having actual time sharing and overnights with his children.
How is this not an issue of reweighing the evidence? I mean, you've highlighted the testimony. Trial court apparently accepted it. You're presenting arguments why the trial court should not have accepted it. But how is that our role?
Okay, I hear you, Judge, but that's I respectfully disagree with your characterization of this. And here's why. What I'm not asking the judge, this court, to reweigh the evidence. What I'm saying is there is no evidence to support the judge's finding, which is clearly an appellate issue. And if we're going to talk about reweighing the evidence,
there's evidence in the record. You're just saying that evidence should not be taken into account. There's testimony that you're saying the trial court should have rejected. Right. Well,
let's look at what I'm actually saying, Judge. What I'm actually saying is he says, I can't work any overtime anymore because of time sharing. Well, we have a parenting plan, which is by consent, that recognizes he's not doing time sharing until he's done the counseling with the children. So the child support guidelines are based on inaccurate income for both parties, the claim that he can't make any extra income in the future, which is purely speculative as a matter of law. And third, we have the statement.
How's that speculative as a matter of law? Isn't that what trial courts do? Isn't that what, for example, imputing income is?
This is not an imputation of income.
No, it's not. But I'm asking, how is it speculative as a matter of law, and then therefore something that the trial court cannot consider?
That's something that's not happening today that someone says may happen in the future, when the actual evidence, the documentary evidence, shows that his income was still including extra income. And even if the credibility question here is, which story of the former husbands does the trial court believe when there's a parenting plan, which is a contract to be interpreted as a matter of law, that says we're not doing child support calculations based on the 31% overnights that will only happen once the counseling with the children occurs. So at the time of this final judgment, which is the picture in time, the point in time that we are looking at, he was not suffering any detriment to his income. He was not exercising time sharing. And the final judgment's child support calculations use both erroneous figures for which there is no evidentiary support for either party, and using a number of overnights that did not exist and would not exist until after the counseling took place, which as of the time of final judgment had not occurred. So the judge has certain discretion, of course, to who to believe and how to take the evidence. But when you've got one part of that being the husband's testimony contradicted by all of the documents that show his actual income, I suggest strongly that that is legally insufficient to make a determination. The child support calculations cannot stand under any view of it. The second part of this, and equally as devastating to my client, has to do with the equitable distribution and her claim for durational alimony. The final judgment erroneously states that my client wanted exclusive use and possession for a year to refinance the home. She sought durational alimony in two alternative ways. One is she wanted to be able to stay in the house with the children and have a year of him helping his durational alimony pay half the mortgage like he always had, so that she could try to refinance it in her own name. And if not, then be able to then list the house because he had asked for partition. The other one was for payment of certain amounts over the course of 3 years, because his actions devastated her financially and ruined what had been historically her good credit rating. She had no child support for 5 months in 2019 after the husband left, no support with the mortgage for all of 2019 until the judge ordered it in 2020. And then after paying 2 months of half the mortgage, he files an emergency motion, stops paying the mortgage, files an emergency motion to get a deferment plan from the mortgagee. And the judge, without any hearing, grants that. And then the husband goes out, instead of getting a deferment where the payments are put on at the end, signs up for a forbearance, which puts the wife in the position of having to come up with money for 3 months worth of mortgage payments after she just borrowed money from her employer to try to get the mortgage out of default, because until she got notice that there was a foreclosure complaint coming, she had no idea that it was happening. And she is the one who's paid for this. And the husband took the position that, well, I never agreed to take this loan. Again, he left the marital home and the children and the wife for whom he had shared the cost of this lifestyle and paid nothing, and thought, I don't have to pay this anymore. His position at trial by his own testimony was, she lived there. I don't have to pay that mortgage anymore, which of course is legally completely baseless. The final judgment failed to equitably distribute that $80-something $100 debt that she incurred to keep the marital property, the marital home, from going into a foreclosure.
But that loan was incurred after the petition for dissolution was filed, correct?
Yes, it was. And it was to preserve a marital asset. There was nothing personal or private about this. This was not just for her benefit. It benefited both of them. The reality is that the husband decided that he just didn't have to be responsible anymore until he was ordered to do so by the court in January of 2020, made 2 payments of half the mortgage, and then filed this motion for deferment and never paid another mortgage payment. So
Can
my
you
client
address the mootness issue? I know that there was a suggestion of mootness.
There was, and Judge, with respect to my esteemed colleague, that's a red herring argument. It goes to the heart of the economic impact of this on my client. Can we unring the bell and make the house be unsold? Of course not. But what the final judgment did not do, and what I am urging this court to do, is recognize the financial reality of what that meant to my client in terms of her claim for durational alimony, is that she got the burden of supporting the children, paying the vast majority of the mortgage, borrowing money to keep the house from getting foreclosed, which benefited both parties, marital asset that benefited both parties, and got absolutely no credit for that. And so she's the one that bore the entire financial burden of taking care of the family and the children and all of this. So the issue is not moot. The asking for the house for a year, that of course cannot happen anymore, but the economic reality, this court needs to reverse and send back for redetermination of the actual financial impact of all this. Once we clear up the issue of the erroneous income and we look at what has exactly happened with the durational alimony claim, my client is the one who bore the brunt of all this, which means that there was an unequal distribution, which without any factual basis for it and without detailed fact findings is legally not allowed, which the Wright case cited in my briefs explicitly addresses. And it also, there was no analysis of the statutory factors governing alimony, which actually prevents us from having a realistic appellate review, because my client was entitled to, as a matter of equity and consistency with all the other family law cases, for some help transitioning from being a single person, raising two children essentially for at least half of this time without any child support, some period of time with inadequate child support, and the child support has been erroneously calculated, that she was entitled to some assistance with the alimony, but we can't really reach it without an analysis of the statutory factors, which the judge failed to provide. And finally, the whole issue about the income tax deduction, my client took it in 2019. There was no court order about who could take the dependency exemption for the children. And she was the one who supported the children with virtually no help from the former husband. He was not exercising time sharing, and they lived with her. She was legally entitled. The IRS reg demonstrating this is attached to my client's motion for rehearing. And the judge, the final judgment, makes it very clear that the judge was awarding, despite the parenting plan's own provisions about how they were going to share this, that the former husband got to take the exemption in 2020 for both children because she had taken it in 2019. That is legally incorrect. It is erroneous to do that without looking at who is being the person that is responsible for paying for these children and where they're spending the most time. It violates the parenting plan, and it punishes her for doing something that in 2019 she had an absolute legal right to do, and he had absolutely no legal right to do. I'm into my rebuttal, and I'd like to save my 3 minutes if I could.
All right, thank you. Ms. Creed?
May it please the court, Rebecca Creed on behalf of Albert J. Ellis, the husband appellee. The husband asked this court to affirm the final judgment in its entirety. When viewed as a whole, it's evident that the trial court did not abuse its broad discretion to do equity. Its findings are well supported by competent substantial evidence in the record, and the wife fails to demonstrate any error as a matter of law. First, as to the FRS pension plan, we likewise will rely on our answer brief. The trial judge did correctly interpret that pension plan as a marital asset and equitably distributed 50% of that as of what the husband would receive in 2039. There is no case law cited that requires or mandates the entry of a quadro. Instead, that's just one tool to enforce a judgment, but certainly no requirement that a quadro be entered. As to the income deduction order and the non-covered medical expenses, we do state that to the extent this court finds those issues are preserved, which we have an argument as to the failure of the initial brief to really flesh out and make those arguments in any detail, but to the extent the court finds that the initial brief was enough to argue those issues, to keep those issues for appeal, we do concede that a limited remand may be appropriate as to those two issues. As to the child support and the calculation of the former husband's income. Contrary to the wife's contentions, there is competent substantial evidence to support the trial court's findings. The husband submitted his second amended financial affidavit, which the trial court accepted into evidence. The trial court accepted the husband's testimony explaining why his overtime was greatly increased in the second half of 2019 because he did not have any time sharing. He didn't have time sharing with the children until after he had moved for temporary relief on that issue. And also explained that his overtime in the spring of 2020 was greatly increased because of mandatory overtime because of the COVID pandemic. The trial court accepted as credible the husband's testimony that those were not reoccurring events and that he would have greatly reduced overtime in the future as contemplated by the parenting plan and the stipulated and agreed on parenting plan number of overnights, and also that a second job that the husband had at times had in the past was no longer available to him. And so again, the trial court's findings are well supported by the evidence, not just the second amended financial affidavit, but the husband's own testimony, the Exhibit 6, which would show the pay scale for the level 9 fire lieutenant and his pay stubs. And as to the wife's income, the wife now makes an argument that, again, I would submit was not preserved. There's a statement in the initial brief as to some misutilization of the gross annual income of the wife, but that's in a summary of what the motion for rehearing stated. And then there's, again, some brief reference to that gross income of the wife in the reply brief, but no argument ever developed on what exactly does that mean in the initial brief. And also, the trial court specifically found that the wife's income, that the wife had testified to her monthly income of $4,464. And that was also the number that was set forth in the wife's own proposed final judgment as to her income level. So we would submit there's no error or misuse or misutilization of some number of the former wife's gross income. The wife asserts a number of times that the husband didn't pay any support after he left the marriage until he was ordered to do so, or until it was in fact August of 2019 when he first began paying the $300 in child support. But as established by the trial court's findings in the temporary support order, and then also in its findings based on evidence at trial, the husband was making contributions to the marital expenses. He was paying the parties' health insurance, both of the wife and the children. He was paying the wife's auto insurance. He was paying other marital debts towards marital debts. And he did, in fact, testify that on pages 1297 and 98 of the record that he had deposited monies into the parties' joint accounts after the separation. The mortgage payment was made in May of 2019, and the husband's testimony was he had deposited monies after that from which the wife could have paid the mortgage. He also, in terms of whether the husband had made 2 months of the mortgage payment or half the mortgage payment after being ordered to do so, the record establishes that in fact the husband made at least 5 or 6 months of payment when he agreed to pay half of the December 2019 mortgage payment, and then he testified at trial that he paid January, February, March, April, May of 2020, he paid that half. And only after the trial court allowed him to enter into a program to defer payments did he stop making that half contribution to the mortgage payment. The trial court heard the evidence as to the forbearance program, and there's nothing to show there's no transcript of the original hearing on that motion to defer payments. But there was testimony at trial to reflect that the wife's projected parade of horribles related to this program were in fact not consistent with the forbearance program that was offered by the mortgage company. The husband testified that there were a number of options. You could extend the forbearance program for another 3 months. You could add the payments on to the end of the loan. You could seek to modify the loan. And so this was a program, again, that was authorized by the trial court, and that even on the wife's motion for reconsideration, the trial court still denied that motion and found that the parties should be allowed to remain in that forbearance program until the marital home was sold. As to the child support issue, so as to child support, we would ask that this court affirm, because there is competent substantial evidence to support the income determination. As to the number of overnights in the parenting plan, we recognize that the parenting plan contemplated that there should be some counseling before overnight time sharing were to begin. It wasn't that you had to complete counseling, but just that it had to have started. That was contemplated as a goal and recognized by the parties in the trial court that the goal was for that overnight time sharing to begin in August of 2020. The trial was July 1st of 2020. So at the time that the trial was held, the parties contemplated, the parenting plan contemplated that the goal was to begin overnight time sharing by August 2020. And in fact, that was also part of the joint pretrial stipulation. And the wife's own attorney stated at trial that we anticipate basically that this is going to happen by August of 2020. So it was not unreasonable or an abuse of discretion for the trial court then to condition or to find that the calculation of child support would include this 31% of the overnight time sharing based on the parties' representations, counsel's representations, the language of the parenting plan itself to which the parties had agreed. And again, not an abuse of discretion to use that number as a calculation of the child support amount. As to many of the remaining arguments on child support, we rest on our briefs, which state and illustrate that those arguments were not well preserved, and to the extent they are, they don't require reversal. The durational alimony, again, there is competent substantial evidence to support the trial court's findings of fact as to the husband's income. The judgment itself does make sufficient findings of fact to allow for meaningful appellate review, both on pages 933 to 934 of the record. The court trial judge goes through each of those statutory factors and makes findings related to those. And so there's enough for this court to be able to review that determination. There are sufficient findings. And as the wife herself recognized by citing to the Wright case, it's only when the omission of findings, that omission of findings is harmful only if it impedes appellate review. And that's not the case here. Again, the findings are sufficient. They're adequately supported by competent substantial evidence. And to deny the wife's request for durational alimony, especially when it's tied in whatever format, whichever alternative, clearly tied to maintaining, keeping the marital home, whether by asking the husband to continue to pay half of the mortgage payment or by requiring him to pay $1,200 a month of durational alimony. The wife definitely tied that request to the marital home. The evidence before the trial court was really that neither party could afford to keep the marital home. The wife couldn't afford to keep it by making payments, but the husband couldn't afford to keep making half payments. He testified to that at trial, and that is consistent with his Second Amendment financial affidavit, which reflects a deficiency in his income, assuming $2,000 less a month than he's making in expenses, if you assume that he continues to pay that half mortgage payment. The home has since been sold, and we would submit that issues related to that durational alimony calculation are moot, and the mortgage has been satisfied. The private loan issue, the trial court did not err or abuse its discretion. The wife never addresses the case law and the statute that we cite in the answer brief related to the cutoff date for determining a marital liability. And here that cutoff date was July 29th, 2019. And that is established that any debt incurred by the wife after that time is necessarily not a marital liability by definition. We cite the Subramanian case where loans incurred by a wife after the litigation commenced could not be classified as marital liabilities. And that is the same instance we have here. And again, something that the wife does not recognize the legal effect of that. To the extent the court's inclined to construe that loan from the mother as some kind of marital debt because it relates to the satisfaction of getting the mortgage current and her loan that she incurred from her mother to do that. There was no abuse of discretion in refusing to compel the husband to contribute to that private loan, or in the trial court's decision not to give the wife a credit, essentially. That standard of review is, again, abuse of discretion. So to reimburse or credit a party for its payment of marital property-related expenses during separation under the Stock case is a matter of judicial discretion in light of all relevant circumstances. Again, the wife's reply brief doesn't address our reliance on Stock or the fact that it really is an abuse of discretion standard. And here there was no abuse of discretion. The wife had been living in the home. The husband did not agree to her obtaining the loan from her mother. And there was some question as to whether she was really expected to repay that. There is a promissory note. She testified at trial that she was obligated to pay that promissory note to her mother, but she also testified, and this is at pages 1539 to 1540 of the record, that she stated she had started to pay her mother back, and her mother said, quote, she, quote, didn't have to, end quote. And so there is at least some question as to really whether this promissory note is really expected to be repaid, whether the wife intended to repay it. And so for all those reasons, the trial court did not abuse its discretion in declining to impose that or to make the husband share in this post-petition marital debt. As to the last issue, which is a claim that the trial court should not have awarded or allowed the husband to claim both children as dependents for tax year 2020. Again, the standard of review is abuse of discretion. And given the circumstances here, there was not an abuse of discretion. The trial court did not act to punish the wife for her 2019 filing. It was not an arbitrary decision. The evidence was that the wife had unilaterally claimed both children as dependents for 2019. Again, the husband did not know about that until he went to try to file his own taxes and then realized he would owe taxes for that year. So at trial, he saw essentially the difference between what he had to come out of pocket to pay and the tax benefit that he would have gained with just one child. And instead of ordering that, the trial court fashioned this relief, which was to allow the husband to claim both children as dependents for tax year 2020. The judge's order also recognized, as to the child support, that there was a child support arrearage on page 935. It ordered the husband to satisfy that with proceeds from the sale of the marital home. And in fact, as we have demonstrated, that arrearage has been satisfied upon the sale of the marital home and the distribution of proceeds to the wife. And that was accomplished before the end of 2020, before December 31st, 2020. So at the time that the husband filed his tax return, which would have been due on or before May 17th, 2021, that child support arrearage had been satisfied. So again, there's no abuse of discretion in allowing the husband to claim that exemption for both children for tax year 2020 when he has provided support throughout 2020 and including his satisfaction of the child support arrearage. As to any remaining issues, would rest on our papers, and we ask this court to affirm in its entirety the final judgment. Thank you.
Thank you. Mr. Grassley?
Thank you. The first issue that we raised, and again, I want to make sure that this is not lost. Once the judge determined correctly, as Ms. Creed acknowledges, that my client had a vested interest in her marital share of the Florida State Pension Plan, then there was absolutely no reason in law or logic why a quadro should have not have been immediately authorized so that nothing could happen to that. It was her property as a matter of law. Excuse me. 3 minutes is tough. The husband's second financial affidavit, which was signed on June 12, 2020, said he made $7,364 a month. And then right before trial on June 24th, he files this third amended financial affidavit claiming $5,038 per month, which was lower than his first financial affidavit where he claimed $5,500 a month. The actual evidence showed that he was making about $7,000 plus a month based on his pay stubs for 2020. Ms. Creed's discussion of his testimony, I asked the court to read his testimony because he admitted nothing except that, well, he didn't think in the future he was going to be making as much. Well, because of the COVID, is why he was making as much as he did. Well, we're still dealing with COVID. This is like speculating that, oh, somehow I'm going to be cut off of the money that I've always made, even though I'm actually making more now than I have been. And the issue about my client's income for purposes of the child support calculation, the judge used $4,538 for my client, and there was no evidence whatsoever to support that figure. That's not what she testified to. That's not what was in her financial affidavit. And the most telling argument that's been made about the child support is, well, the parties assumed and predicted that in August 2020, there would be the time sharing called for by the parenting plan. This was not some aspirational goal. This was what was in the parenting plan. We still don't have any record evidence whatsoever that the former husband is exercising any of the overnights. They negotiated that deal. And until the overnights were being exercised, then he was not entitled to have a child support calculation based on as if it was happening. My client is being asked to bear the financial brunt of all of this because of an erroneous calculation of child support. And this gets us to the last issue, and I will quit on this, which is this marital debt. My client.
Mr. Grassley, your time has concluded. So if you can very briefly conclude.
Thank you.
All right. Thank you both. We will be in recess.
Thank you.